Hello, this is the video lecture for the courts. We've got our typical 15 study guide questions, which I'll go over during our lecture, as well as an essay question that I'll go over. So one of the biggest things about the courts is here called changing the balance, and we'll get into it during the lecture. On the left is Judge Alito, who was brought onto the court several years ago, and the feeling has been from that point forward, the court has kind of nudged to the conservative side. And of course, our talk with Judge Brett Kavanaugh, and that's pretty well solidified, a 5-4 conservative majority on the court. So we're going to look at first the constitutional design for the court and judicial review, the concept of the review, and how we appoint judges. So Article 3 is the shortest of the articles in terms of designing a governmental body. It says very little about powers and responsibilities. It just creates the federal office of the judicial branch. It talks about the chief justices, says they'll serve for life, lays out a little bit of the jurisdiction, which is how do you hear a case, and then Congress filled in many of the details later. So let's start with study guide question number 48 on judicial review. So what is judicial review? And that's where a court interprets and occasionally overturns the actions of the executive or legislative branch. The court reviews and can overturn actions by the legislative or the executive branch. And the case was really set up by Marbury v. Madison, a very famous case in the early 1800s. So judicial review was used with incredible great restraint during the formative years of our country and has increased more in the 1900s and then in the early 2000s. It's much less inclined to stop presidential action. It's a little bit more inclined to to be used on congressional action. And we see it as part of the democratic process, but we often get upset by it because, again, we don't vote directly for judges and they serve for life. Advocates of judicial review, and you have John Marshall, the Chief Justice of the Supreme Court, and Alexander Hamilton on the right here. And they both advocated for a strong national government. And what happened in Marbury v. Madison was Marbury was wanting a judicial appointment in Washington, D.C., and he was one of a group called Midnight Justices that were given a lifetime appointment as Adams was leaving president. And when Jefferson became president, his Secretary of State, Madison, eventually a president himself, refused to actually deliver the petition. It had been nominated and approved, but refused to be delivered, creating a court case. And ultimately, Marbury never got his judicial position, but John Marshall, pictured here on the left, used the case to say that the Supreme Court can declare laws unconstitutional, specifically the Judiciary Act of 1789 that gave jurisdiction in this case. So the case itself is small in the sense of somebody didn't get a petition, but large in the sense that it opened the door for judicial review. So here's detention. This is Guantanamo Bay, and this gets to the deference part. So, President Lincoln suspended habeas corpus during the Civil War, and the Supreme Court declared it unconstitutional 5 years after the war was over. So the chief of the army at that time, McClellan, could detain anybody from Bangor, Maine, all the way to Washington, D.C. And here are prisoners of terror being held in Guantanamo Bay without trial. So presidential actions get scrutinized, but don't get overturned as much. So let's look at the jurisdiction of the court and particularly how it's organized. So federal court really handle cases about the Constitution or federal law, things that happen to ambassadors or treaties, maritime law, places where the United States is a party, disputes between states or a citizen of another state. So they're not just a higher court of the land. You have to do something that fits one of these categories. Otherwise, the state Supreme Court is the ultimate arbiter of something. We have a multi-layered or three-layered system, and we start with what are called U.S. district courts. These are called courts of original jurisdiction, and number 50 says, what is original jurisdiction? And that's a court hearing a case for the first time. They're called courts of fact. It's where the facts are tried. So the U.S. District Court is the initial court where somebody might sue, and it is a court of first resort, is what I would call it. Hearing a case for the first time, it's where facts are decided and a decision is made. So you can have a grand jury, and this is where the great bulk of legal business is done at the federal level. Now, they do have some other courts, and so number 57 is, what courts did Congress establish to adjudicate highly specialized court cases? That's number 57. And for example, there's a court of claims and there's a tax court. So for very sophisticated tax cases, there is a specialty court to handle what they're doing. But for the most part, the district court is that first court. You can see the three-court level. There's 94 districts around the United States. And then if you want to appeal, you go to the U.S. Court of Appeals. That's your appellate or your second chance court. And then the Supreme Court is your last chance court. So the U.S. Court of Appeals is organized by geography. We're in certain districts. I believe we're in the 6th district. I'll show you a map a little bit later. Here's the key part. A court of appeals does not retry a case. It simply it looks at what facts have already been presented. No new facts, no new witnesses. They have briefs, they have opinions. This is all lawyers talking about procedure. Courts of appeals are procedural courts that decided that the first court, the district court, did things well. So appellate courts, number 55, what are the two types of federal court jurisdiction? And it's original and appellate. Original Court of Appeals, and then appellate jurisdiction under the Court of Appeals. Number 59, what is stare decisis? That's a Latin phrase that means let the decision stand. Let the decision stand. And what it means is that courts will use precedent. Previous decisions dictate what the future court will do. So you get a case, you don't just make up your mind, oh, that's right, I'll use my conscience, I think that's right. No, you're guided by the precedents of previous court cases of a similar nature, and that's stare decisis. So here is the picture, and you can see Michigan, Ohio, Kentucky, and Tennessee are in the 6th Circuit of Appeals. And these circuits have different opinions. So in one circuit, you could lean one way, a little more liberal. In another circuit, lean a little more conservative. And then the U.S. Supreme Court, the most famous court. There are 9 justices on the court. That's been fixed since the early 20th century. They can handle some original jurisdiction, very rarely, but for the most part, they get cases on appeal from the Court of Appeals and cases from the other state Supreme Courts, the 50 state Supreme Courts. Their decision is final. So here is the picture of the body and how it works. And I would say, in terms of the Supreme Court and how we see things here, there are about 7,000 federal cases sent towards the Supreme Court, of which they handle about 100 to 150 cases a year. And almost 6 of those 7,000 cases are petitions from prisoners sitting in a federal and sometimes a state prison, claiming that they are illegally there. So the great bulk of work that the court sees are basically petitions from prisoners, and only a handful of them. And so ultimately, about 100 to 150 cases get decided every year. So who are the appointees in the appointment process? And we've talked a lot about this because of the Kavanaugh hearings. So typically exceptional lawyers, judicial experience. They didn't necessarily have to be a judge before, but that's helpful. People look very carefully at their philosophy of justice, what they've written, what they've talked about. Typically, these are people from the upper middle class or upper class. They tend to be more privileged. They've gone to Yale or Harvard or other law schools, so they tend to reflect more of the upper class. The book is not quite right because we have a new person, so I have laid out here the Chief Justice appointed in 2005 by George W. Bush is John Roberts, and that was a big fight to get the Chief Justice because he is a little more equal amongst his peers. He gets the last word on things, the closing vote. You have Clarence Thomas, a conservative, again by his father, George's father, H.W. Bush. Ruth Bader Ginsburg, Bill Clinton, is a liberal, and a lot of talk today because Ruth has mentioned that she has a bit of dementia. Stephen Breyer, another Clinton appointee, so there's two liberals. And then Sam Alito, who I mentioned at the beginning of the chapter, by George Bush. So you've got three Bush appointees and two Clinton appointees, 3-2 conservative to liberal. Now let's look at the last four. And so Barack Obama got Sonia Sotomayor and Ella Kagan. So that restored a little bit of a liberal balance. It was kind of 4-4-1 for a while, with one being more of a moderate. And then Donald Trump has got to put two conservatives on the court, Neil Gorsuch and more recently Brett Kavanaugh. So that really solidifies five strong conservatives on the court and has, these are lifetime appointments of Bush Sr., Bush Jr., Clinton, Obama, and now Trump. The appointment process, and number 47, who is responsible for nominating judges to the federal court, all federal courts, the Supreme Court? Well, that's the president. The president does the nominating. It is the Senate, the advise and consent group that would then approve. Senatorial courtesy is number 46. It says, what is the informal practice of the blue slip? So for a federal district court, and there are multiple district courts, there's one in Cleveland, for example, one in Cincinnati, one in Columbus. So what would happen if an appointment were to come open? You've got Ron Portman, who's a Republican, and you have Sherrod Brown, a Democrat. Both would have an opinion, particularly Portman, since Trump is a Republican, and that's senatorial courtesy. Number 46, what is the informal practice of a blue slip? The Senate Judiciary Committee that hears these nominations solicits opinions from the two home senators. And if they blue slip the candidate and say, no, 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 don't do this one, they often will stop the process at that point. The president has clearly an agenda, since these are lifetime appointments. And there's been several appointments who have been very disappointing. You appointed them one way and they went the other. I talked about Earl Warren, a Republican appointed by the President Republican, Dwight D. Eisenhower, who turned out to be a very liberal judge based upon his experience from the Japanese internment camps during World War II, that executive order we covered. And number 49, what is the term of all federal judges, not just the Supreme Court? Federal judges are appointed for life. So here's number 43, which is, what Supreme Court nominee did the Senate refuse to confirm in 1987? And this is a picture here of Robert Bork. So in 1987, the president put forth a conservative pro-life judge, and Joe Biden, right, former vice president, he was chair of the Senate Judiciary Committee. He did an immediate report about what Bork would do if he was Chief Justice. Ted Kennedy took the Senate floor and gave long and eloquent speeches about it, and ultimately the Senate refused, 58-42. He was seen as too conservative and not appointed. So not even when you have the vote, sometimes it does not go your way. Here's a little bit of Supreme Court ideology. So you can see, on the conservative side, Justice Thomas, Justice Alito, Justice Scalia, and Chief Justice Roberts. Now, Kennedy, who's right in the middle, see, that's that middle judge, He's left the court, and now we've put a fifth justice there who's going to be somewhere between Alito and Thomas. He's going to have a number closer to 3 on the conservative scale. And Breyer, Keegan, Sotomayor, and Ginsburg are going to be 1 to 2.5 on the liberal scale. So it's going to be, there's no middle swing anymore. It's going to be a 5 to 4 conservative majority. The Supreme Court in action and some of their norms of operation. So first of all, the Supreme Court announces its decisions in public, but it meets in secret. It holds a hearing and people can come and talk, but it makes decisions in secret. It makes decisions by seniority. Senior justices they don't get more votes, but they get to vote later in the process. And again, they use precedent. But they can overturn precedent. In Brown v. Board, they overturned the separate but equal doctrine. So there are technical rules that we don't need to go into. You don't necessarily need to know. But the cases have to be real. They're not hypothetical. They have to be ripe in the sense that are important. All other avenues have been exhausted. Somebody has to have been injured. And the Supreme Court will handle a case when 4 of the judges, 4 of the 9, decide, and it's called a writ of certiorari. So they will look at a case, remember thousands of petitions, and they will look at a case and say, should we hear it? They're only going to hear 100 to 150 a year. Their time is precious. They don't have a big bureaucracy working for them, just a couple of clerks. So rule of 4. And certiorari says if 4 justices put their hands up, we'll hear that case. Then there'll be typically briefs filed. So amicus curiae briefs is number 51. What is an amicus curiae brief? Amicus curiae is Latin for friend of the court. Amicus, friend, right? Friend of the court. So an amicus curiae is a brief submitted by someone who is not a party to the case. They're not actively involved in the case, but they have an opinion. So they might be a friend of the court, like a state weighing in for someone or a legal aid society, and that's number 51. When the Supreme Court hears a case, it's not days and days. You have an oral argument. You get 1 hour, 30 minutes each side. And by the way, the Supreme Court can interrupt all 30 minutes. So you got to be ready. You got to be prepared. Then they have a conference, and each judge states their opinion, and then there's an opportunity to structure. Supreme Court Chief Justice will start a discussion, but ultimately end the voting. The decision factors are often previous decisions of the court and the individual ideology of the justices. And they will come out with opinions. And it could just be one opinion, unanimous. There could be an opinion one way, and then you could agree with the opinion, that's called concurring, or you could dissent. So there are anywhere from 1 to 3 different opinions will come out for every case. And then typically a final vote. So I say a vote of 5 to 4, 5 conservatives vote one way. That's the majority opinion. They might write an opinion. And then maybe the 4 liberals will say, oh, no, that's not how we vote. And that fodder of the liberal dissenting opinion may be used by a later court should the people change. So here's clerking with Chief Justice, all smiley figures. But yeah, they have a couple of clerks. So they do all this reading, all this writing themselves. It's hard work. And Justice Thomas, as you will recall, we talked about during the Brett Kavanaugh hearings, Justice Thomas had a very controversial, he was a conservative at a time when we were still, not leaning in that direction. And Anita Hill accused him of sexual impropriety, and it was very difficult. So there were a lot of bad feelings about Brett Kavanaugh, seemingly to put him through this process, like Justice Thomas. Not saying for or against, factual or not, just saying the process. So outside influences on the Supreme Court. So this would be the essay question. And what outside influences are on the Supreme Court? They're appointed for life. They can do whatever they want, but they are influenced. First of all, governmentally, they're influenced by the president and the Congress. So as Congress, the nation changes, Congress passes new laws, president comes in, does new things, and those influence the court over time. The court lags behind. Then there are groups and movements and leaders, public opinion. Those influences also nudge. So when those are all lined up, they could get the court to move in a certain direction. So Hamilton in Federalist Paper number 78 said, the Supreme Court has neither the purse nor the sword, the purse of Congress, nor the sword of the president. But they have the power of words. So their influence by words from other people that kind of come to them. And here's a good example. This is Thurgood Marshall. Thurgood is the representative of the NAACP, and he chose little Linda Brown, who walked past the all-white school to go to the separate but equal all-black school in Topeka, Kansas, to be the case, Brown v. Board of Education, Topeka, Kansas, that became the vote which desegregated this country, separate but equal, which was decided in a precedent by Plessy v. Ferguson earlier in that century, was overturned. And it was a conservative judge that really championed this. Thurgood Marshall, not just a good attorney, he eventually becomes a Supreme Court justice and influences many, many opinions over the span of 20 plus years. So the Supreme Court is a policymaker. They are one of the three branches, and they structure, change, and interpret the Constitution. Number 52 says, what is judicial activism? So that picture of Thurgood Marshall isn't just an accident. He was a classic judicial activist. He was an African American, hoping that African Americans would get a fair shake in this country, and he wanted to make sure that the court took up for the person who didn't have power. That's the way he looked at it. So judicial activism, someone who uses their power broadly to further justice. See, he's saying, look, we have an injustice and the Supreme Court is the final arbiter. We need to correct the injustice. So there are a lot of people that say, no, we shouldn't be judicial activism. We need to have judicial constraint. And I'll talk a little bit about that. Then number 54, civil rights. So this is one of the classic examples of that. And what was the issue in Grove City College v. Bell, Grove City College in Ohio? That's why I picked that. And it's 1984 case, and that is a case about Title IX, whether Title IX applies to private schools, not just public schools. And the answer was it did. That Title IX is the law of the land, regardless of whether you get money from the federal government or not. So that was seen as an example of judicial activism, Grove City v. Bell, Title IX. So structural change and constitutional interpretation. Up until the Civil War, the court was very much about establishing the national government and national power and the idea of property rights, that people had rights under the law. You could just take them away. Period 2 is Civil War to the Great Depression. And it basically is the court being very pro-business. We had a very business boom. The economy took off, the great capital economy of America. And laissez-faire is the question. Number 59, what is the doctrine of laissez-faire? By the way, that's a French expression that actually means doing nothing, the act of doing nothing. You purposefully decide not to do anything. And so it's the meaning that the framers had, that they felt, or at least the theory was, a political economic theory, I should say, that government ought not to interfere in the free market. So we had a free market capitalistic economy. The court needs to stay out of the marketplace. If somebody had gobs of money and was a robber baron and they owned millions of dollars in the 1800s, so be it. Stay out of their way. And that's the doctrine of laissez-faire, that the government should not be involved in the economy. That came to a crash, period 2, during the Great Depression, because the economy broke and could not be fixed without government help. And so the Supreme Court declared some of the acts of the president, Franklin Delano Roosevelt, unconstitutional. And there was a real fight. He thought about putting more justices on the court. That didn't go over very well. But eventually, the Supreme Court changed, and now government is involved in the economy on a regular basis. So from World War II to the mid-80s, remember that case Grove City is 1984, and Thurgood Marshall, 1954, Brown v. Board. So that period was the period of individual rights and liberties, particularly civil rights. So post-World War II, up until the mid-80s, was a very liberal period for the Supreme Court, helping the average person find their way, equal playing field against the rich and powerful. And so after the 1980s, and this is now Ronald Reagan gets elected president in 1980, Ronald Reagan wants to put a few judges on the court, wants the court to be more conservative. So from that period forward, from I'd say 1990, you have those two judges by Bush, and then you have more judges then by Trump. We have the conservative retrenchment. So number 60, what is the criticism of original intent? And I would say it's conservative retrenchment, number 60, which is that the expansion of the rights in period three, particularly during the 1960s, for desegregation and rights about criminal rights, of what that is, that was illegitimate, did not have a constitutional basis, and we need to pull back. And of course, the sentinel, the number one, is abortion. That was just going too far. The Roe v. Wade case in the 70s. So conservative retrenchment is a criticism of the doctrine of liberalism, and it says we should have original intent. The framers did not intend that to happen. This is what we should follow what they originally intended. Here's a timeline. Again, the beginning with the national powers and property rights, and then the government in laissez-faire in the economy, the government getting into the economy, individual rights, and then conservatism. So all this fight over Brett Kavanaugh has to do with, are we still in this period of conservative entrenchment? And even though we're a divided country, the court is going to be conservative. So the debate over judicial activism, judicial review has increased. So originally, the conservatives felt that the court shouldn't be involved at all. But now they've seen what's happened when liberals took action using the court. And so even conservatives say, oh, we have to act. We can't just be restrained and do nothing anymore. And so they've been looking to reverse some of the decisions of the Supreme Court. They would like to undo some of the things, particularly in the criminal field of rights for criminals. And they are, in fact, more political than they have been. And so strict construction is number 56. What is the doctrine of original intent or strict construction? That the court must be guided by the meaning of the framers, the exact words of the Constitution. Has a very biblical ring, right? People that believe the Bible is the Word of God, the exact words, follow those words. It kind of follows that tone. Framers wrote the document, do what the framers said, you'll be good. But I think today, even the strictest of strict constructionists understands that there has been so much movement on the liberal side, you're going to have to react to that and pull back, and that's going to take an activism. This is reduced damages from the Exxon Valdez. So in 1989, in the Puget Sound in Alaska, the greatest spill in the history of the United States, and there were billions of dollars in damages. A conservative Supreme Court in 2008, headed by that new Chief Justice Roberts, pulled back many of those damages and said that was a bit too far. So when I say conservative, it could just be lessening of the damages that was done to somebody. And here we are in deciding the presidential election of 2000 when Florida was narrowly decided. So Florida's electoral votes got to go to the Washington, D.C. They elected George Bush as their president, and the Supreme Court, by a 5-4 vote, sided with President Bush. And, had there been another liberal judge or two in the court, Al Gore probably would have been the president of the United States. We'll talk more during the interactive exercise, but the essay asks you to look at the court's new agenda. So this is whether the Age Discrimination Employment Act is that small companies need to do that. Here's another one on the Eighth Amendment and whether a prisoner with mental disability can be spared from particularly the death penalty. Here's another one on separate sovereigns, what it's called. You can be tried for a crime in a state court and a federal court because it violates both laws. And then the federal arbitration one in New Prima versus Oliveira, a more technical case. And then here's another Eighth Amendment, whether the excessive fines is applicable to the states. Now, interestingly enough, should Brett Kavanaugh sit on any of these cases, he is ineligible because they were heard before he came to the court. So these might wind up 4-4 because Kennedy's left and he was that moderate that cast that kind of vote one way or the other. But he could start voting on cases, Kavanaugh can, from there forward. Well, here's the essay, and I've talked a little bit about those. And the key cases in the interactive part gives you some fodder to kind of work with. But again, those two influences I talked about, which are Congress and the president is one, the governmental, and then the non-governmental, which are typically lobby groups. It could be NAACP, it could be the National Association of Manufacturers, whoever they may be. So that closes this lecture. I've covered the courts. I've also covered a little interactive part, and we'll get to that in class, as well as all of the study guide questions. Hope you enjoyed this lecture.